We really found that the accusations against Grand Canyon, which is a faith-based organization, and we looked at all the facts of the case.
I am familiar with the university.
Really,
my question is, how are those students going to be made whole if you are not allowing the university to pay the fines? What's the plan?
I'm not sure that that's the right analysis of it.
This segment opens with a fragmented but substantive exchange regarding allegations against Grand Canyon University. The speaker references having reviewed the accusations thoroughly, emphasizing that the institution is faith-based and that all relevant facts were examined. The discussion immediately frames the issue as one involving regulatory oversight, due process, and fairness rather than ideology. A central concern is introduced regarding student restitution and whether rescinding financial penalties undermines the ability of affected students to be made whole, setting the foundation for the broader policy debate that follows.
The gentleman, I recognize now the gentlelady from Minnesota, Ms. Omar.
Thank you, Chairman, and thank you, Madam Secretary, for being here with us. Is it fair to assume that you are aware that when a loan borrower is defrauded by a school, that there is a provision in law called the borrower defense?
Yes, I am.
Okay. It is a straightforward concept. A student should not be forced to repay loans to schools that lied to them. We know that millions of federal grants and loans go out the door while students are left with education that is not worthy. So I was actually surprised a few weeks ago when your department quietly rescinded $37 million fine that was placed against Grand Canyon University. Can you explain why that happened?
The procedural tone of the hearing becomes clear as the chair formally recognizes Representative Ilhan Omar of Minnesota. Omar begins respectfully, thanking both the chair and the education secretary for appearing. This clip establishes the formal structure of congressional oversight, where elected representatives question executive officials on policy implementation. The respectful opening contrasts with the intensity of the policy questions that follow, reinforcing the seriousness of the oversight function.
Let me think for a second. Let me review my notes on that because there were a couple of things I wanted to make sure I covered with you. We really found that the accusations against Grand Canyon, which is a faith-based organization, and we looked at all the facts of the case.
I am familiar with the university.
Really,
my question is, how are those students going to be made whole if you are not allowing the university to pay the fines? What's the plan?
I'm not sure that that's the right analysis of it, but I will look into it further and get back to you.
And you'll give me back a writing?
Yes, I will.
Writing? Okay. Because we know that, you know, the president in whom you serve had a fraudulent university called Trump University, and he himself settled 3 lawsuits before becoming president. We know that there are roughly 1.4 million borrowers who have been approved for a borrower defense discharge and are still waiting for that process. How are you clearing out that backlog?
In terms of the borrowed defense funds?
Uh-huh.
You know, there are lists of that. I'll be happy to get back to you with those numbers.
Okay. And while those students wait, can you give us a commitment that you are not going to collect that debt?
Yeah, I'll have to get back to you on that as to what the situation is. And
I don't understand how that's a difficult question to say yes to. They've been defrauded. They are waiting for relief. While they wait for their relief,
well, if
they shouldn't have to pay back that debt.
Well, if they've been defrauded and it's been adjudicated that they've been defrauded, then I will get back to you as to what the time frame is and why there's a holdup if there is.
Okay.
I'm not sure as I sit here right now.
Representative Omar introduces the legal concept of borrower defense, a statutory protection for students who were misled or defrauded by educational institutions. She frames it as a straightforward and morally grounded principle. Students should not be required to repay loans incurred through deceptive practices. The Secretary acknowledges familiarity with the provision, confirming its legitimacy and relevance. This exchange grounds the conversation in existing law rather than political opinion.
Wonderful. There was, I know that you've been questioned a lot on IDEA and its funding. I won't re-litigate those questions. I just have two particular questions to address, or two areas to address. We know that the IDEA, that you have gotten rid of the legal team that guides the states in implementation. How are you going to rectify that?
I don't know what you mean by we've gotten rid of the legal team. We have had some reduction in force of
There was a
members.
firing of the entire legal team.
Well, we have other lawyers in place at the Department of Education, and we are
The
fully...
entire team that was for IDEA has been fired. So how are you addressing that?
Because we have other lawyers who are in place that can handle those things. And as I mentioned before, we have not missed any of our statutory requirements.
Omar expands on the scale of the issue, referencing large amounts of federal aid distributed while students allegedly receive substandard education. She expresses surprise at the Department of Education's decision to rescind a $37 million fine against Grand Canyon University and directly asks for an explanation. This clip highlights congressional concern about transparency, enforcement consistency, and the implications of regulatory reversals.
I do believe that firing hurts the implementation. We also know that you have gutted the Office of Civil Rights when there is already investigation backlog. How are you going to fix the discrimination claim cases that are out there?
Well, there are, excuse me, there are cases that we're looking into. And again, we have not missed any of our statutory requirements in terms of OCR. We also have a task force.
There is a backlog. There are a lot of
There is a backlog
There are a lot of
because we
kids in our schools that are waiting for relief. When you get rid of the people that are supposed to carry out those investigations, how are you to assure that those kids will not continue to be harmed? We are talking about so many situations in where kids are being discriminated against, and you got rid of the people that investigate those investigations so those kids can protect themselves from from discrimination.
Well, we still have a very strong and capable staff in OCR. At the
Then
Department
you
of
wouldn't have a
Education.
backlog if that was the case. There is a current backlog, and I would...
Secretary McMahon responds cautiously, explaining that the department reviewed the case carefully and evaluated the accusations based on available facts. She emphasizes deliberation and accuracy rather than immediacy. Her response reflects an administrative approach focused on internal review processes and evidentiary standards, rather than political or public pressure. Omar presses the issue further, returning to the central concern of student relief. She asks how students can be compensated if the university is not required to pay fines. The secretary indicates that she does not agree with the premise of the question and commits to reviewing the matter further and responding in writing. This exchange demonstrates the tension between legislative demands for immediate answers and executive reliance on process. The discussion shifts to the borrower defense backlog. Omar references a significant number of borrowers approved for relief who are still waiting for discharge. She asks how the department plans to address the backlog and whether borrowers will be protected from collection efforts while awaiting resolution. The secretary acknowledges the existence of data and timelines but does not provide immediate specifics, again offering to follow up. Omar challenges the lack of definitive answers, expressing frustration that borrowers who have been determined to be defrauded may still be required to make payments. The secretary responds by distinguishing between adjudicated cases and unresolved ones, stating she needs to confirm timeframes and causes of delays. This clip underscores the complexity of implementing large-scale relief programs within federal systems. The focus moves to departmental staffing, specifically the legal team involved in guiding states on policy implementation. Omar asserts that the entire legal team was removed, raising concerns about the department's capacity to meet its obligations. The secretary disputes the characterization, stating that while there were reductions in force, qualified legal staff remain in place and statutory requirements continue to be met. The final original clip addresses the Office for Civil Rights and an existing backlog of discrimination investigations. Omar argues that staffing reductions exacerbate delays and harm students awaiting relief. The secretary responds by maintaining that the office remains functional, capable, and compliant with legal duties. The exchange ends unresolved, reflecting ongoing oversight tensions and differing assessments of administrative effectiveness. What this entire exchange ultimately reveals is not just a disagreement over one fine, one university, or one administrative decision, but a much deeper tension at the heart of how modern governance, accountability, and public trust intersect in the education system. At its core, the debate surrounding Grand Canyon University, borrower defense, and departmental enforcement highlights a fundamental question that continues to surface across institutions. How do we balance due process with urgency, and how do we protect students without allowing political narratives to override evidence-based decision-making? Linda McMahon's responses emphasized procedural review, fact-finding, and adherence to statutory requirements, reinforcing the idea that government agencies are bound to act within legal frameworks rather than emotional or ideological pressure. That position, while often criticized as bureaucratic or slow, reflects a system designed to avoid arbitrary punishment and ensure that penalties are imposed only when claims are substantiated through proper investigation. On the other hand, the concerns raised about students who feel misled or financially burdened are not imaginary. They represent real people whose futures are shaped by debt, delayed relief, and prolonged uncertainty. The borrower defense process exists precisely because past failures showed what happens when institutions are allowed to operate without oversight, yet the presence of a large backlog raises legitimate questions about capacity, staffing, and prioritization within the Department of Education. Saying that statutory requirements have not been missed may be technically accurate, but technical compliance does not always translate into public confidence, especially when thousands of borrowers remain in limbo. This tension becomes even more pronounced when discussions shift toward civil rights enforcement and legal infrastructure, areas where staffing reductions or restructuring can have long-term ripple effects on vulnerable populations. Education policy is not abstract. It directly affects students navigating discrimination claims, accessibility challenges, and institutional accountability, and delays in those processes can quietly compound harm even when no single rule has been violated on paper. What this hearing also demonstrates is how easily serious policy discussions can become overshadowed by political theater, where interruptions, sharp exchanges, and performative outrage take center stage, often at the expense of clarity. While oversight hearings are meant to hold officials accountable, their effectiveness depends on whether they generate actionable information and solutions rather than simply reinforcing partisan divides. Faith-based institutions, federal oversight, student loan relief, and civil rights enforcement are all complex issues that require nuanced discussion, yet they are frequently compressed into sound bites that travel faster than facts. The broader challenge, then, is not just determining whether a fine was justified or rescinded appropriately, but whether the systems in place are transparent enough for the public to understand why decisions are made and how affected students are supported afterward. Trust in institutions erodes not only when wrongdoing occurs, but also when processes feel opaque, slow, or dismissive of lived experiences. Rebuilding that trust requires more than confident testimony or procedural assurances. It requires measurable outcomes, clear timelines, and consistent communication with those waiting for relief. At the same time, it is equally important to recognize that accountability must apply evenly and responsibly, without assuming guilt or wrongdoing in the absence of verified findings. The rule of law depends on restraint as much as enforcement, and due process exists to protect both individuals and institutions from unjust outcomes. Ultimately, this moment serves as a reminder that education policy sits at the crossroads of ethics, economics, and opportunity, and how leaders navigate these discussions signals their priorities. If the goal is truly to protect students, then reforms must address both prevention and resolution, preventing misleading practices before harm occurs, and resolving legitimate claims efficiently when harm has already been done. That requires investment in staff, modernization of review systems, and a willingness to engage beyond partisan frameworks. When debates focus solely on blame, they stall progress. When they focus on structure, transparency, and results, they create space for meaningful change. The real measure of success will not be who delivered the sharpest exchange in hearing room, but whether students emerge with clearer pathways, fairer treatment, and confidence that the system exists to serve them rather than confuse them. In the end, education should be the foundation upon which opportunity is built, not a battlefield where policy becomes secondary to politics, and moving forward demands a commitment to facts, fairness, and solutions that extend beyond the moment and into lasting reform.